South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
Let me just give a quick introduction before delving in some of the topics that we have in store. It's clearly a topic close to the hearts of the panelists, each of them being very seasoned litigators, and ma'am also being on the bench. So something which everyone's dealt with firsthand. So I think it's better to have them give out experiences. But just before we delve in, I think one thing that I wanted to highlight, and picking up from where ma'am said about the legitimacy of the arbitration process, one of the things to keep in mind is that arbitration still, as of date, is the most successful out-of-court alternative dispute resolution mechanism available internationally and nationally, simply because of the New York Convention and, of course, the Arbitration Act. Now, that being the only alternative, we're talking about the person who will decide this dispute, decide the arbitration, and quite frankly is at the core of the dispute resolution process. So the topic today is very interesting because it directly affects the legitimacy of the process, where people opt for arbitration, trusting that they will have a fair, neutral deciding that dispute. And today's topic delves into bias and the thought process that goes into disclosures and challenges. Let me start off with the role of disclosures. Why is it important in the arbitration process, and maybe some experiences on what the panelists have seen on how a disclosure has maybe changed the process of a dispute that they were in. Rajshekar, if I could start with you.
Thank you, Pranav. I think the answer is in that first question. Like you said, we have the whole purpose of arbitration is to be a substitute for a formal adjudicatory process. And the edifice of this entire structure rests on integrity. Now, integrity is not about how I perceive. I mean, I usually use this line, so that old adage of I think, therefore I am. From an arbitrator's perspective, they think, therefore you are. It's because parties believe that you are somebody that they can vest their troubles in, and you will therefore give them a fair opportunity, is really what the foundational basis is. So I think, as Justice Pushkarna pointed out, the statute has been amended. It's ironical that we have to amend things to say that these are obvious aspects, but it's important to be reminded. So from that perspective, why disclosure? Because that is the foundational basis of the entire process. Should you disclose? The answer is yes. If in doubt, err on the side of disclosure. Now, what does disclosure mean? Disclosure means that as an arbitrator, I believe that these are facts that I need to place on the table so that all of you who have placed your dispute before me are satisfied that I don't have any predilections, that you're satisfied that I've made a clean breast of where I stand, qua the dispute, qua the parties, and as the statute says, any other kind of association. So we've seen, and I think, this is a cultural thing, the requirement is of the arbitrator. The arbitrator is expected to make that disclosure. It's not for parties to go looking and do a fishing and roving inquiry. Surely, therefore, the foundational basis must be, please make a full disclosure. Not only do you encourage parties to be more confident in you, you encourage parties to be more confident in the process. We've had instances where you call upon an arbitrator who's made and we have a form today. The form is filled up. There seems to be some ambiguity. A party comes forward and says, sir, can I ask you a question about this matter that you say that you've done? And some arbitrators take it personally. You have to keep your ego outside. You have to remember that you're part of a larger process. And it's in that backdrop that disclosure is required. We have another problem today. You make a disclosure, but you feel that I have disclosed too much. What happens then? But I think we are all in alignment that at the end of the day, a full disclosure is absolutely warranted. We've had a recent situation where the statute suggests that, your disclosure requirement continues throughout the process. An arbitrator says, listen, I've already heard you. I've just received another appointment from another government agency, which is, in a sense, involved with this. But I am now at the stage where I have more or less written my award. Should I make a disclosure or not? Why not? arbitrator has taken a view on a subject, on a particular clause. It's a shipping transaction. There are, 5 clauses that you'll find in every second dispute. If I have taken a view, do I have an obligation to make a disclosure? Now, what is the consequence of me not having disclosed the fact that I have rendered 3 awards on that? Now, I may have held in favor of a party on 1 and against another party on 2. But these are all private matters. So the whole purpose is really that. I think the way I see it, please encourage a process where everybody feels confident when you walk out. I think you speak to the average litigant. The litigant only wants a fair hearing. Everybody wants to win, but at the end of the day, we all understand where we stand. And therefore, from that perspective, the foundational basis necessarily has to be disclosure and nothing more. I believe there is a certain trend which says we will limit disclosures because too much disclosure is also a problem. There, fortunately, we are not in virgin territory. We have enough guidance from the world over. And it's important for arbitrators to take recourse from those. And it's the green, orange, and red. We all know what the consequences are. The reason I emphasize that disclosure is important is because arbitration is not a cheap process. And the theme of the topic is uniting law, governance, and philanthropy. An arbitrator must understand that an expensive process becomes even more expensive when an arbitrator errs on the side of not disclosing and therefore leads both parties, up a path which is easily reversible and which easily prevented. So please be kind as an arbitrator, please be fair as an arbitrator, and please disclose. I think that's the way I see it, and I think in more cases than not today, we see arbitrators are willing to disclose. The problem is, at times we're being prodded. Why is there the need to prod? And that's something that I feel we're changing. It is a process. We are effectively 25 years down the line from the Arbitration and Conciliation, nearly 30 years now to the Arbitration and Conciliation Act. By now, I believe we should have had a process where these aspects should no longer be a problem. The fact that we are debating it still is to me a cause for concern and a cause to rejoice. The fact that we are able to have a full and frank disclosure and a discussion on this aspect of the matter.
Thank you so much. Neelima, your views on this?
I think Raj has covered most of the territory for us. I may not have to speak so much now. Really, I divide the whole arbitration process into 4 steps, where I see that there is a need for, the parties, the litigant particularly, to know as to what his or her rights are. The first stage is the disclosure stage. The second stage is the proceedings where the requirement of the due process and other requirements as per the Act arise. The third stage is the award and the scrutiny of the award, which is unfortunately completely absent in India because there is no institutional arbitration. If there was institutional arbitration, then most institutions normally provide for a scrutiny of the award itself. And then, of course, the award itself and the 34 rights, whatever are the grounds for challenge. Coming back to the first stage, again, under the first stage, you could have some benefit if there was institutional arbitration, because the institution itself will also scrutinize as to whether the arbitrator may have any conflict of interest. So, to that extent, that can be very beneficial. But as of now, since that is mostly absent, we have a situation where disclosures are made. At least in my working experience, I have mostly seen the disclosure to be written as nil. Any conflict, nil. The only thing written in the form is nil. There is none. Sometimes we are lucky. We go on, as Raj says, a fishing and roving inquiry. We go into the public domain. We actually find something which tells us, yes, there is a possible conflict. What happens thereafter? I have a right under 13 to file an application and seek further information under 12 and 13. Now that information, unless it comes, I am still in the dark, partly in the dark. So if the full information had come, I could perhaps have gone under 14 also, because there I would have a more definite case. But if that information is not coming, then I have to wait till the stage of 34 when I can actually challenge it again. So perhaps an institutional system of arbitration is something which is very desirable because it can bring in a dual process where the litigant also can do its own inquiry, whatever little is available in the public domain, and also the institution can be of help. But really, the provision as it stands now really requires that it is the duty of the arbitrator to disclose. So if there is a failure of duty, your only compensation is that you can eventually then again challenge the award. But then one has to wait for this whole time and the whole process of arbitration to get over. So perhaps if more stringent or more detailed requirement of making the disclosure is there, other than just Schedule or 5, because 5 and 7 is not really exhaustive. There can be several other types of conflicts, and in one of the recent Supreme Court judgments, it was held that it's Schedule 5 plus 7 plus whatever else is available under 12. But 12 does not really define it. So perhaps it was, if it was a more, even more detailed, and if you see, sometimes the parties are hesitant to ask. Sometimes the arbitrators may not be forthcoming with the disclosure. So I think somewhere we need to find a solution to this problem as well. But having said that, the 2015 amendment which brought in the requirement of disclosures has been a very welcome change, and it has changed a lot of things after that.
It's a very interesting point that you raised, Nilima, and I think one way, at least, that SIAC addresses this is that we take away the power of appointment from the parties. So the parties cannot directly make an appointment. Even if they jointly agree, they can only nominate an arbitrator, because it is easier not to appoint an arbitrator than to later challenge him or her on grounds of independence or impartiality. And that appointment takes place only after SIAC conducts, we send across a comprehensive conflicts checklist to the prospective arbitrator, ask that they sign the code of ethics that we have, where we ask them explicitly, if you have a disclosure to make, please tell us now. And that's been quite helpful for us in making appointments, because once we receive these disclosures, we tell the parties, tell us if you have any objections to this, if you want to change your mind on who you're nominating. So it sort of, we've seen changes in who's been nominated as well, and helps remove, because once an arbitrator is appointed, by framework, it's a difficult process to get them off the tribunal. The idea is to have that person decide your dispute than anybody frivolously challenging it. And so that's one way, at least SIAC as an institution helps. Mayani, do you have any views on disclosure?
I think it's been covered well and comprehensively, and I'm in this unenviable spot of speaking after Justice Pushkarna and Rajsa and Nilima ma'am. So I'm not going to say much. I'm just going to say from the institutional perspective, because I worked briefly with the ICC. In practice, we used to have this unsaid sort of practice that if there was a non-disclosure and a subsequent challenge, the subsequent challenge would always be evaluated considering that non-disclosure as an aggravating circumstance. And the reason for that is that over a period of time, the independence and impartiality, or the lack of it, reflects in the manner that the proceedings are conducted. So you have, procedural irregularities coming along the way. You have decisions which show sort of a non-application of mine in procedural in procedural orders. And so when you have then the discovery of a circumstance which could have been known before to the parties, and they could have had the opportunity to correct the course of the arbitration right in the beginning, and that is not given to the parties as a benefit that they could have exercised, you consider that as a circumstance that justifies the removal of the arbitrator and therefore a successful challenge. So in addition to, of course, the duty of disclosure and the consensual nature of the process, I think there is also an underlying obligation on the arbitrator to conduct the arbitration in an effective and time-bound manner. And the fact that there is a successful challenge eventually derails that. So that's another reason why it's always good to have a disclosure. Let the parties decide. And in fact, there have been cases where there have been disclosures and then a challenge, and the arbitrator has rejected the challenge, which is fine also. You can disclose circumstances which are akin to, for example, the orange list under the IPA, and have a party challenge the arbitrator, and then the arbitrator says, well, you know, I don't think I am partial or not independent. So I think that is the more fruitful outcome, is to have the disclosure.
I think it also helps with institutional arbitration, especially, is that you have someone from the institution copied in on correspondence and on the proceedings. Right. Yeah. So you have, the institution has a sense of what's actually happening, and if there is, you know, misconduct, then you can flag it well before the parties bring it in. So
yeah, and that's interesting, because the thing is, the institution senses a challenge much before it comes. You know, because you read the orders and you read the procedure, and you have an institutional memory. You've worked with that arbitrator before, so you know it. But you could have done something, like you said, at the stage of disclosure, but you can't do anything once the arbitration is underway until there is a challenge. So that's the role that institutions play.
Ma'am, would you have any comments on disclosures and how they add to the legitimacy of the arbitration process?
Yes. See, arbitration is seen as a process which is by consent of the parties. And it is seen as an alternate dispute to the actual courts who are dealing with the adjudicating the disputes between the parties. So therefore, it is imperative that an arbitrator discloses all what is material in terms of the act, which could raise doubts with respect to the impartiality or the or independence of the arbitrator. And it's very clear that as far as arbitration process is concerned, the independence and impartiality of the arbitrator is the main foundation of arbitration. Because if that was not so, then where is the question of having any alternate dispute resolution process? Because impartiality is the main foundation. And this disclosure has to be not made only at the commencement, but in case during the proceedings, the arbitration proceedings, if there are some circumstances or situations that arise which the arbitrator feels that should be disclosed to the parties, the arbitrator should certainly disclose that and not keep to himself or herself. Because otherwise, the whole process, as Mr. Shekhar also said, that arbitration is a very expensive process. So therefore, in case the disclosure is not made, and at the end of the day, the court is to set aside the award on the basis of any bias or impartiality because there was some non-disclosure, then it is not only expensive for the parties, but also for the court, because courts are already burdened so much. Especially in India, if we see the judges hearing 100 matters a day, and then if they're burdened with this, and then the whole process has to start all over again, it defeats the whole purpose of the arbitration.
And of course, the parties might be less willing to opt for arbitration the next time on because of their experience.
Yes, absolutely.
And they're both burdening courts more often.
You know, if you just allow me to add, I think if this is seen as a legal right of the litigant, that I have a legal right to know, then perhaps I think the attitude can change. Because sometimes, at least in my experience, I can say that, you know, people, if you ask for disclosure, people feel offended, which I think should not be there, because this is something this is a right which is provided by the statute to the litigant. I mean, just borrowing an example from the courts. If the honorable judge is hearing a matter and if it is brought to their attention, and which is something we see all the time, that somebody known to them or they themselves while practicing as lawyers had appeared in the matter, they immediately recuse themselves. I mean, there is not even a second thought about it. So similarly, if somebody has been asked a question pertaining to their possible independence or impartiality not being there, then I personally think, because this is a legal right, there is nothing to be offended, because That person is asking because they have a long way to go, they have a big cost to incur, huge cost in fact, before they really reach the end result. So perhaps looking at it from this perspective, things can be, a little different.
I can just add to that, sorry. With every right comes a corresponding duty. Here the duty comes first. And the duty is cast in recognition of the right of a party to choose. So unless, and you owe it not only to the parties, you owe it to the entire process as an arbitrator. And please, I think we've all seen instances where arbitrators have made disclosures which in the ordinary course to the average person may seem like, I don't want this man or this woman to hear my matter. And parties have both said, no, we believe you are absolutely equipped. Now imagine the credibility of an arbitrator who makes a disclosure which seemingly seems, shocking or slightly out of the ordinary. And both parties say, no, we have full faith in you. The credibility of the process just goes up manifold. I think that's the approach that we need to inculcate for this process to actually work itself out. And then the 34th challenge becomes even more limited. We see many instances where a judge looks at us and says, you may be right, but look at who the arbitrator is. Now, in a sense, it's irrelevant. But the relevance is because the process trusts these people.
Picking up from there, Neelima, if I could come to you on what, so if a party does want to enforce its right to challenge an arbitrator, for whatever reason, we've passed that stage of disclosure, there's either been disclosures or non-disclosures, and now someone wants to go up and say, we want this person off the tribunal. What would you say is the state of law on these challenges as is in India right now, and especially also in context of how the Indian Arbitration Act is unique in that it incorporates the IBA guidelines and what's your view on this?
So, yes, we have the IBA guidelines incorporated. Of course, it doesn't call it the green, orange and the red, but we have the Schedule 5 and the Schedule 7, which incorporate the orange part of it and the red part of it. So, I would say the Section 12, like I said again, I think what we discussed in the first round is really certain loopholes or certain requirements or certain deficiencies that we see ought to be there. So in that context, for instance, I think Section 12 is very wide because it says any ground which may lead to a thinking, and I would add the words of a reasonable man, that there is any doubt as to independence or impartiality, then the party has a right to proceed. Now the question arises, in what time do I have to exercise that right? Needless to say, I have to exercise as per the law, and Section 13 gives me a time of only 15 days from my date of knowledge. Now that date of knowledge can be disputed. There is also a requirement that I should have challenged it earlier before I can challenge it in 34. I can't straight away go and challenge it in 34. But what if the award has come and I have become aware only after the award was pronounced, or sometime during when the award was reserved? So those can be a few grey areas. But other than that, the procedure is quite well defined. I can go under Section 13 and ask for a consideration by the arbitrators of the challenge to their own independence and impartiality. If the decision is made, then of course the next challenge lies under 34. But there is nothing which bars me if I have something I feel is covered by Schedule 7. But the grounds under 5 and 7 are overlapping. But 7 is when you have, let's say, a more definite proof of what you think is a ground for challenging. Then a Section 14 can be made, and then of course the next step of a 226 and then the SLP. Needless to say, like all good Indian litigants, we always exhaust all stages of challenge. We never spare any of them. So the challenges are there, the grounds are there, the procedure is there, and I think it's a very fair procedure because 15 days is enough time to find out if you have any grounds or apprehensions available. And it's not too long because otherwise it may delay the proceedings. So the procedure is there, it's quite well set, but as we discussed, there are a few lacunae which still need either an interpretation from the court or need to be set to rest by an amendment perhaps.
Sorry, if I could just add an anecdote to that. There was a case where that we were discussing yesterday where I was sitting as arbitrator and there was no real ground for a challenge because there was no disclosure or the lack of it and they couldn't find any conflict. And then they used this admirable ingenuity of challenging the process itself. And they took out all the orders in which I had given extensions of time or denied them and said that, if you compare them, more extensions of time have been granted to one side to make submissions as opposed to the other. And I thought that was interesting because what that indicates is that even if you don't find a clear challenge, an indication of bias can be found in the manner in which you conduct the process and eventually challenged before the arbitrator and then at the stage of a 34 for procedural irregularities, which I thought was interesting. So just my 2 bits on it.
Just to add from an institutional standpoint, we've seen, this is of course the ad hoc process is where you go before the arbitrators and you challenge and they decide the challenge. But if it is an institutional arbitration, then there's a committee, at least within SIC, a committee of the SIC court that's constituted that looks into the challenge. And now typically you see these last-ditch attempts at challenge after the hearing where the same thing, right? They come across with what the procedure has been and then they take excerpts of the transcripts to see they asked more questions of one side over the other. And therefore, there's some allegation of bias because by that time you probably know where the tribunal is and what their thinking is. And so to that extent, you see some of these challenges come in. And I haven't seen them succeed. Okay. So just to close that loop. But that's going on to the next segment of this. And Rajshekar, I'll pick your brain on as a counsel for the parties, at what time do you decide and what are the considerations you take into account before you decide to make that challenge? What do you look at from a practical standpoint? If you're seeing an arbitrator, you think there are grounds or you'd want to argue out different grounds, what would you look at?
So, okay, let me step one step back. And I think at that point in time, it's the lawyer that's the most important cog in the wheel. Because, if it strikes you as a lawyer that there is a problem, then of course it is your obligation to flag it. But more often than not, it is your client who's prodding you on the side because he or she has some notion of impartiality or the lack of independence. And you are the filter. Again, I keep going back to the process because the process is paramount. You are the filter that determines whether in the first instance there is even a credible basis for a challenge. Number 2, is that basis founded on a green, orange, red? Because that then dictates your remedy. The last thing you want is to go before an arbitrator and say, I think you're not independent, I think you're partial. So you have to find some way to justify to yourself as a professional that you have a credible ground to urge a de jure or a de facto inability. Because that's the easiest remedy. You go to another authority which decides that. And then, of course, then you go through the motions. As ma'am says, the process is very well streamlined. But I thought maybe one more thing. As a party, if you want to have the ability, Section 12 also says you have the ability to decide the process of challenge at the time of drafting. How many of us spend time negotiating the arbitration clause when we negotiate an arbitration agreement? And surely we are missing the wood for the trees because you're so hung up on the agreement that you don't focus on the little things in the arbitration clause which actually give you, it's all founded on party autonomy. You have the ability to push your way. And if you have the ability to push your way, you should put in some things. Right? So why do I need 15 days? Why should I be restricted to that? Can I not have a clause which says 15 days doesn't bind me? Because that's what we've agreed. It's an agreement to the contrary. And purely as a matter of fact, the 15-day rule is there to ensure that the process is paramount. But what happens if I'm able to establish, notwithstanding from an objective standpoint, that the arbitrator has technically ruled himself out of the equation? Then does the 15-day rule impinge upon the court's ability at 34, to say, listen, it's all right, it doesn't matter, the process is paramount. So from that perspective, I think please be very, very circumspect, because you are also questioning, and while, the line is a withdrawal from a proceeding when there is a challenge is not a reflection on your integrity, the sad reality is 9 out of 10 times it is seen as that. So every time you mount a challenge, you are not only delaying the process. Of course, I mean, if you're using it as a guerrilla tactic, by all means, please do so. But please remember, it is not, it's frowned upon. And again, somewhere along the way, we are all responsible. We must be responsible. So it's not the only time you may be, your client may not be before that arbitrator. You may be before that arbitrator 15 other occasions. If you've mounted an insurmountable challenge, and ultimately you failed, you end up with egg on your face, you end up with your credibility getting affected, and somewhere along the way you let some mud stick to an arbitrator also. So from that perspective, I think choose your battles. When you choose them, please take it home. Don't be circumspect. And like you said, as a young lawyer, I was once before a tribunal of 3 former Chief Justices, and I had a very, very senior client. I mean, he was nearly 80 years old, and he always felt I was too diffident before that tribunal. He says, Raj, you must be more aggressive. I said, sir, 3 former Chief Justices. He says, former Chief Justices. They are arbitrators today. Their positions don't matter. They are there because we chose them. So put that baggage, that cultural baggage, unfortunately, is a cultural baggage, and we must learn to deal with it. But if you find that an arbitrator is crossing a line, and as Manani points out, even in process, you have an obligation as counsel to start flagging that issue then and there. For 2 reasons. One is because then you are doing the arbitrator an injustice by not flagging it. And if the arbitrator chooses to continue to toe a line, which effectively gives you the ability, then you've also helped yourself build a case on evidence by the order sheets and your repeated objections. But please, yes, be mindful of the lines, don't cross them. And when you do have to cross a line, please cross it purely on legal and factual basis and for no other reason. Like I said, guerrilla tactics work at times, but at the end of the day, your credibility gets impacted.
I actually have a follow-up question to that, Rajika. So you said that sometimes it's because the client's prodding you. Would you think, just to be fair to arbitrators as well, there's greater scrutiny on arbitrators as it would be, say, if they were in court, that clients somehow take more liberty in pushing allegations of bias?
Absolutely. And which is why I said, you are the only one who's defending both positions. As a sense, you become the arbitrator of that little point for a few seconds. And number 2, I think from an arbitrator's perspective also, I believe the average person is there because he or she wants to build a reputation in a process where people will want to come back to you notwithstanding positions that you've taken. Right? That's why I said, so you have to trust the inherent goodness or the willingness of each professional who wants to put themselves out in this space. It's a very small world. I think everybody knows. Arbitrators
very
who are
strong grapevine.
Absolutely,
yes.
It's a very strong grapevine. So nothing is hidden, and we've had instances where awards are tested beyond the line that a 34 provides, only because even the judge is aware that so and so arbitrator may not necessarily always be somebody who toes the middle line. So purely from that perspective, yes, I think each of us, are cogs in a larger wheel. We must remember that wheel can only function if the hub and the spokes work. The difficulty is the arbitrator is the hub. If the hub is wobbly, then the wheel will never run. And which is why disclose, be fair, be unmindful of the fact that that a client or one of the parties has the right to criticize. But yes, don't let them cross lines. You don't cross lines yourselves, for sure.
If I may just add to that, taking a slightly contra view, but not exactly contra, but Section 13, which lays down the 15 days time limit, yes, one can perhaps play around with the arbitration clause itself to try and overcome that. But that really is a time limit for challenging the appointment. Section 12 has no such time limit. So if I have an apprehension or a reasonable apprehension, as I would say, based on some material, that there is a doubt as to the independence or impartiality, I have a right to seek disclosure under 12. There is no time limit under 12. The difficulty is that what if the disclosure is not made? Firstly, because my time has technically begun then, under 13, because 15 days is the time. From the date of knowledge, I have to. So even though there is no time limit under 12, while I am seeking the disclosure, I am, because of 13, bound by the time limit of 15 days. Secondly, what if no disclosure is actually made even thereafter, and which is unfortunately very often the case, because disclosures are not made, then what do? I still cannot sit there, I have to proceed. So perhaps if there was some provision by which making of the disclosure is made mandatory, perhaps it could help the situation and it could perhaps sort out the issue much faster.
Does a Section 14 challenge then lie? I've asked a question and the arbitrator says nothing, chooses to ignore it. Then should he or she not be de jure ineligible? If you can't inspire confidence by answering a simple question, are you conflicted?
Yes.
Then you are definitely conflicted, whether you like it or not.
I had a hearing where we sought disclosure, and again, they were very reputed arbitrators, and the arbitrators were very upset, so they called a hearing. And they said, you tell us, don't you have confidence in our ability to judge this dispute? And then, of course, at that stage, you say, nahi, it's like my bap.
I think there is a segregation between ability and independence, impartiality, which needs to be appreciated. Because nobody is challenging the ability there.
By the arbitrators.
But that sort of, I think, squarely fits into the next segment, coming to you, Manini, on as an arbitrator, how would you or how should you be viewing a challenge? And little to what Justice Pushkarna touched upon that time as well on how should you view a challenge? And what does your duty entail when you receive a challenge? What should you be doing ideally? Or what would you do as an arbitrator, and how would you process it? What factors would you consider? What would you look at?
I think this has already been covered quite well, including in the opening remarks. I think there are two positions that you have to be conscious of. The first position is that as an arbitrator, you are, like I said before, duty-bound to ensure an efficient process. And once you've picked up the heavy banner, then you have to carry it through. So you have to have the gumption not to be fazed by frivolous challenges. Just in an attempt to appear integral and to not have yourself challenged before an appropriate court, don't give up on your position if you think that it's a frivolous challenge and it's a disruptive tactic. That's one side of the story. And the other side of the story is that if it has come to a challenge, then either there has been some non-disclosure on your end. In those cases, I would prefer to acknowledge the fact of the non-disclosure and give the party the benefit of the doubt that if it had known of the disclosure, it might have adopted a different approach to my appointment. And so I would give into that. But other than that, I think we have an excellent yardstick in the green, orange, and red lists of the IBA. And I think almost all situations of conflict can be properly assessed vis-a-vis something in those lists. They come close to that description of conflict, or they are analogous to those positions. And so I think it's okay that when there is a green situation, factual situation, to reject the challenge. When there is an orange one, to consider it very seriously and rule in favor of the challenge. And of course, the red is out of the question. So I would not draw a line through the water on this one. I think it is something that an arbitrator has to take a personal view on. I have been in hearing rooms where one party has visibly tried to rile the arbitrator into a reaction, and I have seen very, very good arbitrators go through it with poker faces, and there is a lot to learn from that. So you should not be the person who's getting riled up. But if you are, even if the challenge is a weak one, and then you ask yourself the question that after this challenge, am I going to be able to be impartial to both these parties? And if the answer to that is no, then I think you should in any event give up your position. And this has been done before. There are cases at the ICSID where this has been done, where an arbitrator has said, well, I don't find merit in this challenge, but the proceedings have become so acrimonious and hostile towards my appointment that I think it's appropriate to resign. So I think it's a high standard to meet, but that should be the appropriate standard.
It's quite interesting, but do you think that sort of ties in with the arbitrator's duty to the parties? If they do find that the challenge is frivolous, clearly meant to derail the proceedings, how would you balance that with with their duty to the parties? Like, I mean, we've been speaking about how expensive the process is. And you say on the final stages, closing submissions are due, and this challenge comes in, and clearly frivolous, but meant to derail the proceedings. Would those would the stage of the proceedings go into play? Would the cost that the parties have expended
Absolutely. Absolutely. And thank you for raising that. That's a very important point, because a lot of times the challenges come with a bid to postpone the merits hearing, which is something that I think should be looked at far more closely if it comes at that stage. But again, it goes to the merit of the challenge. I would not outright reject a challenge simply because it is an attempt to derail the process. If there is, in fact, merit in the challenge, and one of the parties has grounds to believe that I will not be in a position to now carry forward this arbitration in an independent and impartial way. But you're right, there have been challenges simply with a view to delay proceedings. And like I said, you have to have the gumption to power through that, and also trust in the institutions that support you. Because there have been cases where, a lot happens before an arbitrator, but then you have faith that it's eventually going to go to court. So just keep the faith, that even if you are the strong arbitrator and you reject a challenge, eventually it will go to a judge or someone with a higher authority. In fact, there have been orders that I've issued where I've actually said that in the order that this sort of objection will eventually be looked at by the appropriate forum, but I'm not the appropriate forum. Not in the context of a challenge, but there are such issues that do arise. Once during a hearing, somebody said this very verbally to me, saying, you have a reputation for imposing costs for delay. So at which point I said, that perhaps that is a reputation that you can take to the appropriate forum and, not raise before me. I think that's appropriate. Yeah.
Coming to the institutions that support the process, ma'am, it'd be interesting to hear your views on when you're sitting and you're looking at prospective appointments and you're looking at different candidates who you'd want to appoint for a particular matter where parties have been unable to agree. What would you consider? Would you look at your potential disclosures that the arbitrator makes, or would you also keep an eye out on previous conduct of that arbitrator and other matters in your experience before even making that appointment?
While appointing arbitrators, one of the objection is, of course, that the disclosure has to be made. So even at the time when appointment of an arbitrator is made, so before that only, the arbitrator, the proposed arbitrator is enjoined upon to make that disclosure, and only then it is confirmed, the appointment of the arbitrator as such. So that's what the judges follow while sitting on the bench. And yes, with respect to as to the kind of person who should be there, like they say, the grapevine works, the reputation follows. So people are by and large aware of the persons who would be proposed arbitrators. We know about them, and that's how, because once you are aware and you are sure about their impartiality, it's only then you go ahead with the appointment of an arbitrator. But of course, yes, there have been instances like during the process of the arbitration, people have raised these objections with respect to bias, like she just mentioned. So I also came across a case where the allegation against the arbitrator was that he was giving too much adjournments to the other side and was magnanimous in giving adjournments. And another case which I came across was that the other party was allowed to file their statement of defense belatedly despite taking a lot of adjournments. So they say the arbitrator is being partisan because when we wanted to file something, the same magnanimity was not given to us. So sometimes the arbitrator as such is not perceived as a biased person at the commencement of the arbitration proceedings, but during the proceedings of the arbitration itself, the way the arbitrator is conducting himself, the parties watch that and then they make their own notions. They may be correct, they may be false, but that's the kind of notions which people make with respect to impartiality or biasness of an arbitrator.
In fact, that brings a very important point on time availabilities as well. At the time of appointment, arbitrators might have more time on their hands to take up the appointment, but when these submissions come in, they might be very busy and might be willing to grant these adjournments simply because it suits personal schedules, and that's something that is difficult to monitor. But of course will, like you said, affect how they're perceived in their proceeding.
I'd like to add something. So when we are appointing arbitrators, so we do have a table which I asked from the concerned court staff, etc., with respect to the number of arbitration a particular arbitrator, a judge, etc., is already dealing with. Because then you have an idea with respect to whether or not that person would be able to do justice to the arbitration proceedings.
Very similarly, even at SIAC, where we have to make that appointment, while we don't know how many other appointments they might have, if someone we've recently appointed, we prefer not to make the same appointment because we know that person will be busy.
Because at the ICC, we actually have that table.
Yeah.
They request you to indicate
calendar.
your ongoing arbitrations. It's the soft way of doing the exact same thing.
Add something more controversial to this mix.
Yes.
Right. So, just thinking aloud, ma'am, we have court-appointed arbitrators, we have institutional arbitrators, and we have ad hoc. What if a court appointing an arbitrator requires the arbitrator to make a disclosure to the court before the appointment is made? Would I, as an arbitrator, adopt the same approach as I was making a disclosure to the parties? And if statutorily, especially since we've still not reached that stage where institutional arbitration has taken over in that sense, that's the hope. And if an arbitrator violates that undertaking or is found to have made a false disclosure, does that tantamount to obstruction of justice? And I'm saying this with some responsibility because somewhere along the way, it also depends, my seriousness of disclosure also depends upon who's asking. An institution, yes, but a judge asking me that question pre-appointment means that I'm actually being tested and I'm being asked because obviously the court has faith in my abilities. But do I live up to it is the short question. And do I have the ability? And that's the point that Pranav is making. And it's something that it's bothering all of us professionally also. How much work can you take on to be able to actually do justice to it? And at some point in time, the new recommendation is that you can only have about 15 at a given point in time, from what I understand. But surely that is the least that people expect. A client comes to you, parties expect you to give your time. It can't be that, you spend 25 minutes to 30 minutes at the end of every hearing trying to find a date, especially in a 3-member tribunal. And it could be 3 months, it could be 6 months, it could be 8 months. And then we are the laughingstock of the world at large. So I'm just wondering, ma'am, whether it would be a useful thing to call upon an arbitrator. I know it's again, we are dealing with people who have held office. But just to say, can you give us a disclosure? And then we can move forward on the strength of that disclosure. And then of course you make a disclosure to the parties itself. And the order, instead of saying that the arbitrator makes a disclosure to the parties, the order appointing says this is the disclosure that we've received from the arbitrator. Does that elevate the status of the disclosure?
So to just answer this query, like I said before, that at the time of appointment of an arbitrator, the judges do it in 2 stages. One is, you say that so-and-so person is proposed to be an arbitrator, and the parties are directed to go and seek disclosure from the said proposed arbitrator. And once that's taken, then on the next day of hearing, then the appointment of the arbitrator is confirmed. So it's done in 2 stages to ensure that the actual disclosure does come.
Just also on this point, when I think with the benefit, different institutions again have this differently, but with institutions like the SIC, you follow a schedule of fees and you go on an ad valorem basis, because the institution holds the purse strings, because ultimately you're paying their fees basis their conduct during the course of the arbitration. Arbitrators tend to be a little bit more forthcoming and tend to be a little bit more efficient during the process, because the costs and their fees are determined at the end of the proceeding, after the institution sees how they've actually conducted it. whether there have been inordinate delays, and that there are penalties that are imposed as a result. So that sort of helps streamline the structure a little bit more, and as a result, when, if there are disclosures that are sought for and they're not made, and there's a successful challenge, question is whether they should be paid and by how much, also goes into the institution's decision making. So that sort of helps in it's a carrot and stick approach. You do well, you get paid.
That's useful because there's a conspicuous omission of the equivalent of 13.6 and 14. So if your award is set aside because your challenge, which was unsuccessful before the arbitrator, is successful before a court in 34, the court can determine whether the arbitrator shall retain all the fee. But in a 14 where the arbitrator is de jure and de facto ineligible, there is no such provision. And parties are out of pocket, both in terms of money and in time, and therefore more money. Yes.
But on delay, the reduction of fees is a real fear. I must tell you. It's a hanging sword through the arbitration.
So, like to just add to this about the arbitrators' fees, like in the Delhi High Court, Delhi International Arbitration Center, they have a schedule there that if the award is made within so much of time, then this is the fees you will get, and if it's then in a particular point of time, it just gets decreased. So I think that's answers that if you're doing it properly, the fees you get paid for that.
But with that, I see that our time is up. Thank you to all the panelists for their fantastic insight on this.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.